Section 18. Imperfections of the Writ. We have seen that there were good times and bad times in the common law system, to which has been attributed the peculiar merit of having a flexible character, enabling it to be accommodated to the condition, exigencies, and conveniences of the people. But personal liberty was subject to these fluctuations and changes, and it was in the bad times that this right was violated. This called for improvements in the remedy by writ of habeas corpus. The imperfections attached to relief by means of this writ would probably have not stood in need of a remedy, had they not been incident to this unwritten and flexible law. For instance, had the common law in regard to the granting of the writ of habeas corpus in vacation, as declared by Coke and Hale, been stereotyped, a process to which common law lawyers on both continents express a positive and intemperate aversion in a statutory form, it is said that Lord Nottingham would not have ventured to make that declaration of the common law which tarnishes his bright fame. It was this peculiar nature of the common law, its flexibility, we may say, that caused the two conflicting currents of authority, in the profligate reign of Charles II, as to the power of the Court of Common Pleas to grant writs of habeas corpus. It appears that the speedy trial of prisoners was sometimes evaded by colorably assigning a treasonable or felonious cause for their commitments, but as to this, Chief Justice Vaughan, in Bushell's case, stated that upon a commitment for treason or felony the prisoner may press for his trial, which ought not to be denied or delayed. It was declared in the House of Commons, by North, when Attorney General, that at common law no man can be imprisoned but in a legal prison, nor sent abroad but in order to trial. And as to the place where the writ would run, the Court of King's Bench, in 1668, bad issued a writ of habeas corpus at common law to the Governor of Jersey. Andrew Amos, Esquire, in treating of this topic, makes a very beautiful allusion to mythology. The common law was doubtless, in some respects, chargeable with inadequacy, but personal liberty was chiefly compromised by means of its uncertainty and flexibility, and of its springing, in a great measure, from the heads of judges, not always with the like happy result as when Minerva sprung from the head of Jupiter. He further says, sagaciously did Lord Nottingham insert in his Miss Treatise, called Prolegomena, a separate chapter, which, if continued to the present day, would fill a large book, entitled Le Leges del commonly ont agreed to alter it sans acte de parlement, et l'unemi,